I negotiate licenses. So if you've ever uploaded photographs to the web, many years ago, one of our clients had that technology, and one of the larger companies now in the world negotiated a license with my client. That's what I do. So I'm not giving legal advice, I'm just waving my hands. So remember, when we talk about legal principles, the law in common law, I'm a California lawyer, moves by exceptions to the general principle. So I'll be talking in generalities today. But I'm not talking from a perspective of a lawyer. I'm talking about la storia di errore di proprietà intellettuale vera, la storia vera. So we're going through about 6 stories. This is my favorite. 2 parole and 1 bilione euros. Magari 10 bilioni euros. Another one, 7 million euros. Then it goes from there. So, we're gonna, how much time do I have? 20 minutes, 25 minutes? Okay. Okay. So, let's start with the first principle. You come up with an idea, Louise, right? Okay? You don't tell anybody, right? Somebody else comes up with the same idea. They put it on paper and they commercialize it. They've not violated your rights. They own the rights because they reduced it to a physical medium. Scrivere, software, the cloud, okay? So that's the main principle, fundamental principle. The one exception is if you're an employee, automatically the intellectual property you make for your employer is theirs. So, remember one thing at least from this presentation, that you need a written document and it should have the right language. You cannot orally transfer intellectual property. There's no such thing as an oral contract for intellectual property. This cost between $1 billion and $10 billion. By the way, if you need a translation, raise your hand and we'll quickly do it, okay? You can't say, I agree to assign my IP. Now, we start from this basic premise that a company should own the IP for various reasons. Among them, you have more value, and if you're venture capital backed, they will require it. This is what you need to own. If you're doing a platform, you need the underlying platform or a license to it. You need your programming. You need your design, look, and feel. Features and functionality and tools to make more. Here's what many people miss. Hello, Liquid Factory people. The data, the incoming and outgoing results can be a revenue stream for you. So you need to think about owning it. For example, when you have an AI agent you create, you negotiate with somebody to use their LLM or their proprietary information, right? And you create new data from it. Who owns it? That becomes crucial. In some cases, the data you generate is more valuable than whatever you're selling or licensing. Google, for example. Okay, here's the first story. It's about Stanford University. Nobody looks closely. This is their logo. Nobody looks closely. It's actually in German. Now, does anybody know about what the football team is called at Stanford University? In America, the university football teams are very important. Do you know what Stanford's called? Nope, they're called the Tree. It's just the weirdest name. By the way, unfortunately, you can't see it, but it's technically called Leland Stanford Junior University, which gets people confused. Leland Stanford and his wife's son, Leland Stanford Jr., died. And so they decided to found the university in his name. By coincidence, my great uncle and aunt, Zio and Zia, were in the first graduating class from Stanford in 1897, by coincidence. Okay, so they lost between 1 billion and 10 billion euros, meaning they couldn't collect the revenue because of 2 words. Oops, sorry, wrong direction. Okay so far? Everybody capiche? Okay. So here's what happened. There's a new genetics research professor, walks into Stanford and says, hello, I'm here, I'm your employee. And they signed an assignment agreement with Stanford University. The assignment agreement means that I give you everything I create while I'm here. Okay? Very important to remember. The most important thing to remember about this case. I give you everything while I'm here. Okay, Stanford is helping startups in the area in Palo Alto. And down the street, there was a venture capital funded company called Cetus. Very famous, bought by Roche for many billions of dollars some time ago. There at Cetus, he signs an NDA, and it says, whatever you create here, we own, unless somebody else has the prior rights. Who has the prior rights to what the researcher will create? Stanford, right? Because he said, I assigned everything I do here. Very important. This costs them between $1 billion and $10 billion, okay? So, Cetus works with this guy, he comes up with brilliant ideas, they create the products, and they start selling it, and they start making millions, tens of millions of dollars, okay? And Stanford sues and says, we owned all the IP. What does Cetus say? Stanford loses at the district court, the appeals court, and the US Supreme Court. But wait a minute. The researcher signed an agreement giving Stanford all of the IP while he was an employee. So what happened? In other words, let's suppose that I own this, okay? And I assign it to Fabrizio. Then I come over to Scott and I say, Scott, I'm going to sell you that, right? Yeah. Well, I don't own it now, okay? So Stanford was saying, James didn't own that IP, we do. So they lost all the way to the Supreme Court. Here is the problem, bad contract language. They never owned the IP from the genetic researcher. But wait, he signed an assignment agreement. We, Stanford University, own it. Not so. What's the bad language? Can anybody find the 2 words? Anybody want to try? What are the 2 bad words here? That's close. Agrees to. Okay. Scott, I agree to give you a ride to Milan. I'm not giving you a ride to Milan, I agree to. Right? Means I'll do it in the future. Agree to assign, right? What's wrong? There's no assignment. It's a promise that I agree to assign it, right? 2 words, $1 billion. The research agrees to assign something sometime in the future. Okay, got it? So what do you need to say? Present tense, researcher hereby assigns. You can even cut out this because this is present tense, right? Like presento, io presento, right? It's present tense, okay? So this is the case, you can read it, called Stanford v. Roche. It's very, very interesting. Of course, I'm a geek when it comes to law, so I know. Okay, understood? Good? Well, All right, so what? Use the present tense, read the agreements. Most IP lawyers did not expect this decision, by the way. They thought the language was okay. Now, Stanford University is worth maybe $100 billion, right? One of the wealthiest universities in the world. They can hire any lawyer in the world. And they hired a lawyer who wrote that. Probably should have known better. Imagine that. So you can imagine where that lawyer is today. Okay. So let's go to the next one. So there is a company, we'll call it Cartoon Development. These are all true stories, by the way. Cartoon Development Corporation has rights. I can't tell you which one, but they have some rights to a cartoon. They are converting it into a game for children, and they need a voiceover. Do you know what a voiceover actor is? Okay. So they hired a voiceover actor. They could have lost $7 million. Startup, VC backed. Okay, here's the critical thing. They said, listen, voiceover actor, we need you to start tomorrow, right away. We need to get this thing out right away. Just get going. Just go. Fine, fine, fine. So the actor does it, records the voice, everything's done. They pay her, off he goes. Okay, big hit, gigantic hit. You can imagine one of these characters that it was very, very, very popular. So they decided to do a second version, right? So they decided to do a second version. They call up the actor and they say, listen, can you come back and do the voiceover again? And he says, sure. He comes back to do the voiceover like this, right? So then I'm there. I get a call from my client, says, you better talk to this lawyer. His lawyer calls me and says, the actor never assigned the voiceover in your first version. Sold millions of copies, right? It didn't sell millions, it sold 7 million worth, put it that way, okay? He said, we're going to shut you down unless you give us what we want, right? So, thinking, okay, the lawyer will ask for $1 million and can get it, right? So, what's happened? The actor owns the voice recordings. My client would have to recover and destroy all the copies or pay the actor. $1 million maybe 100,000, maybe 2 million, right? It doesn't matter. Would have had to pay, right? And the VC backers would have said, you violated your representations and warranties because you said you owned everything, okay? So guess what the lawyer asked for? Double the day rate and the SAG card, Screen Actor Guild's card. The day rate was $750. He wanted $1,500. He could have gotten $1 million. So, lessons learned. Get a written agreement in place before the work starts, okay? Remember, if somebody writes it down, remember the first, second, or third slide? Reduces to a tangible medium. You reduce it to a tangible medium, you own it. So, get the written agreement in place. Don't say, God, we got to start. We got to hurry, okay? Now, don't you like the name I chose for this company? Naive. Isn't that Italian for naive? Okay. Huh? Oh, how's this spelled? Oh, naive. With a V. Oh, sorry. Naive. Naive means sort of a wastrel. So, okay. So, third story. This company hires a software development company to make a medical sensor device. Oops. Okay. They're called deliverables in legal language, meaning, I need you to make this device. It's called a deliverable because I've delivered it to you. Or it could be software code, whatever, it's deliverable, okay? That's all they said. They said, once you pay us, we transfer all of your deliverables. Notice present tense. This is contingent present tense. In other words, this obligation is triggered by this happening first. So it's contractually bound to occur. Okay? That's how it's different from Stanford v. Roche. Okay? Important point. They create the deliverables by using their own tools. In an agreement with software development companies, the software developer always gets to keep his or its tools, right? And it's heavily negotiated too, because you often want to say my tools and any enhancements to it while doing it. Okay, so who owns the tools? Answers? Anybody want to guess? Who owns the tools?
Who owns the IP?
Who owns the IP to the tools? Okay, why? Wasn't agreed to. In other words, the agreement did not include the tools, and it almost never does, but sometimes it does, okay? So, who owns the software and why? Well, here's the variation. Naif does not pay. SDS, the software development company, owns it until payment is made. If payment's never made, they never assign the agreements. Because remember, we have this language. Upon payment in full, triggers the transfer. So this is a fight that's going on. Why? Because Naif wants to file for a patent. Okay? So they want all documents, all the tools, all the prototypes. But what did the agreement say? That's what the agreement said. How can they get anything else? They want prototypes, everything else. Because they realized they could get a patent from what was created in medical sensors, right? But you can't retroactively go back and do that. So they have no claim on anything other than the deliverables. The software development company owns everything. They'll transfer the deliverables on payment. And that's all this company gets. You can't retroactively go back and do it. Okay. Now, Naif engages an independent contractor. This is Alice in Wonderland with the White Queen, right? Okay. And it turns out the independent contractor doesn't own what Naif thinks she owns, because she created deliverables that were similar to those for your current client. She'd already created them under an independent contractor agreement with another client. So that client owns that IP. Plus, that former client of hers also owned all the tools, because that's what she was building there. So as a result, Naif does not own the IP of whatever she created as an independent contractor for them. They can show that its deliverables are not based on her tools or her previous deliverables. Then they could be okay. But if Naif's client is sued, so here's Naif, here's the independent contractor, here's Naif's client, then here's somebody else Naif's client was giving them software to, Naif will have to pay a lot of money to the client because they had an indemnification provision and reps and warranties that they owned the software, the deliverables, the core of the deliverables and their tools, and they did not. Fifth story. This one, you have no idea how often this has happened in my career. People bring it to me after this has happened, okay? So, Naif gives a license to Stupido that says, Naif hereby grants the stupido an exclusive license for the term to the IP identified in Exhibit A for use solely in Exhibit B. Okay? So we have two exhibits that are part of the agreement, A and B. A says, here's the IP, supposing it's a description of this. Okay? B says how they can use it. How they can use it, where they can use it, for how long they can use it, etc. Okay? Now, they never had any Exhibit B attached to the agreement. They never signed it. They had no evidence the parties ever exchanged drafts. Now, there have been cases, situations where they did exchange drafts of Exhibit Bs, multiple versions of them, but they still didn't come to an agreement. So as a result, we ask ourselves this. What can Stupido do? Okay, Stupido's received software, or received the deliverables, right? Okay? Do they have any restrictions? Can they sell it anywhere in the world? Any guess? Boy, everybody's really awake. Am I really that exciting? No. You think no? Okay. Why?
That was written on Exhibit B.
Correct.
I say yes.
They can. Correct. Can they make derivatives, new products and services
Which one was correct?
that they can sell it anywhere in the world?
Because Exhibit B doesn't exist.
Exhibit B has, there are no restrictions, right? What about this one? Make derivatives. Okay. What about this one?
Sure.
Trick question.
If they had a non-compete, yes.
Well, non-competes are unenforceable in California, but anyway, they probably can't. And the reason why is a judge would say this is an impossibility doctrine. Why would they license to somebody else to compete against them, even if there are no restrictions? That's just kind of an obvious one that the parties would have intended. Can they sublicense to a third party?
Yes.
Yes. Okay. Now, anybody heard of a company called Apple or Microsoft? Anybody remember? You probably weren't even born. Version 3.1 of Microsoft's Windows. It was the first one with a graphic user interface, GUI. It was the desktop, visual desktop. Do you know where it came from? Apple. Every single version of Microsoft's desktop came from Apple. Right? Apple might have lost $1 trillion, depending upon how much money was invested in Windows machines over the last 42 years, right? Because they had a license that did not constrain the use of the technology they licensed to Microsoft. And they lost. And Apple had some of the best lawyers in the world at the time. And they lost. And Apple almost went bankrupt about 2 years later. Interesting, huh? So, think about what you're giving to people and what you're receiving. Okay. Stupido signs a development agreement with another company, Geniale. Is that properly written?
Yes.
Okay, good. To consult, a consulting agreement. They say, okay, you should paint this blue, you should, expand it in Germany. They give advice. Okay. So Stupido likes them so much that they ask them to develop software. Okay? Geniale is such a genius, it doesn't hire a lawyer to specify what is being made, what the deliverables are. Now, when you make a deliverable, under the law, there are certain implicit warranties you're making. Under the law, you're warranting it's not going to blow up in your face, it's not going to kill somebody, right? You have title to it, you own it. There are a whole bunch of other ones, right? Under contract law, you can do what is called disclaim. Disclaim in Italian, they don't apply. You say, we agree, that stuff doesn't apply. It's called disclaimer of warranties. They didn't have a lawyer, so there are no disclaimer of warranties. So Geniale could go bankrupt from their indemnification obligations and the breach of warranties if somebody sues. So Geniali suffers damages because the deliverables didn't work. So they sue for breach of warranties, and Geniali wins, and Stupido has to pay millions. One of my friends was representing a startup that was providing deliverables and services to Fox, 20th Century Fox, right? We couldn't do the work because we represented MySpace at the time. But he told me later that Fox got sued for the use of the deliverables by his client, and that client had indemnification obligations, meaning if a third party sues Fox, the person providing the deliverables has to cover Fox's costs. Well, Fox is a multi-billion-dollar, because this is 15 years ago, multi-billion-dollar company. This startup is making $2 million. So they just handed the keys of the company to Fox because they couldn't cover. Okay? All right, how are we doing in time? Okay? We're okay? All right. So many people, when they get agreements, say, I can't possibly read this. I don't understand legalese. If it's in your native language, you certainly understand enough. You can read it. We urge clients to read the agreements. And you need to ask, what is the IP involved? Who owns it now and who will own it during and after the agreement? And how can they use it? What are the limits on its use, whether for you, your use, or for theirs? Okay, last story, right? This is happening as we speak. Open source software has been a common issue. And the problem with open source software, very quickly, is many developers use open source software, as they should. But a lot of open source software has certain automatic licenses attached to the open source software. So if they put that open source software into a deliverable for their clients, right, and they give it to their clients, the clients may get in trouble because they might not be complying with the license inherent to the open source software. So you have to be careful about that, disclose it, and say it's up to you. Now, what's happening right now is that clients are using ChatGPT, Claude, several others to create software code, okay? And they immediately put it into something, a deliverable to their client, and it doesn't work, okay? Now, if you're a software developer, you're going to disclaim your warranties. The MSA is a Master Services or TOU, terms of use, okay? You're going to disclaim the warranties, saying, look, I can't warrant this won't blow up in your face, okay? But they do have indemnification obligations, which is to say that if the client receiving your deliverables is sued by a third party, and it's your deliverables causing the problem, you have to cover their costs of defense. And that's what's happening with artificial intelligence code. The code is bad, and so things collapse. Things don't work. So what? First of all, the IP mistakes often occur when there's so the first ones I talked about, like the two words, that's problems with the language in the intellectual property provisions of the agreement. The last ones I talked about occur because of the interaction between provisions in an agreement, okay? Now I know, you're saying, why is he telling me this stuff? Why I'm telling you is that if you're a CEO or a CTO or a senior manager of a company, you are going to have to make decisions about this. And your lawyers will ask you how you want to decide. Then anything on the web or created by AI is not necessarily available to you. We've had dozens of clients call up and say, I'm being sued because I use this photograph or this video that's on the web. And if it's on the web, it must be in the public domain. Well, that's not true. Okay? And you've heard of Getty Images? Getty Images makes a fortune contacting people and saying, hey, you used my image of Venezia, or you used my image of Ronaldo, right? They don't sue you for $100,000. They sue you for $1,000 or 1,000 euros, right? So it's just enough to make it hurt, but not enough that you won't pay it. They're making a fortune. In Germany, by the way, there's a court where anybody with a copyright that they think has been infringed can go from anywhere in the world to the German court and get a judgment against somebody using their image or their content anywhere in the world. So we had a client who found a photograph. They were sponsoring a conference in Amsterdam. And they found a photograph on the web of the train station and the beautiful tulips and the word Amsterdam there. And they put it up to announce their conference, right? And they got sued in a German court for it. And they were based in the UK, Canada, and the US. They had 3 different offices, right? They're not going to fly to Germany to pay, this is in this case, $3,000. So they had to pay. Okay, so in closing, does anybody recognize this handsome dude? I'll tell you a quick story. Do you have some time for a quick story? It's very interesting. My wife is an Italian art lawyer and works in photography, but she wasn't involved. So this famous wildlife photographer goes to Sulawesi, one of the big islands in Indonesia, to take photographs of the macaques. And he sets up all of his equipment. And these macaques come rambling along. And one of them comes up to the camera and goes, click, and takes a selfie. So it went viral. The photographer sued people claiming he owned the copyright to the photograph. Well, did he? Maybe not. Did he not take the picture? He set up the camera, but Naruto, like my imitation of Naruto, except he didn't have glasses. So he's so cute. So it went all over the courts and everything else and everything. And Naruto won. The guy did not own the copyright to the image. Naruto took the photograph. So they did reach an agreement where the photographer would pay a certain portion of every time that his photos are used to the Naruto Save Naruto Fund. So and these animals, they're quite big and they're very, very sweet. Anyway, so to summarize. So you need all the licenses. Make sure you have them. Be thorough. If you're going to use somebody else's IP, make sure you have a written agreement in place in advance. Make the present tense for the language. And your independent contractor agreements, make sure you have it right. In other words, if you're doing deliverables, it's not a consulting agreement. If you're using exhibits, make sure people sign the exhibits. Okay, you should always have NDAs in place at the very beginning. It's just basic IP hygiene, including exhibits. This is what you need to do in the web. Get their permission or don't use it. And that's it.